survived the flood, but when the water dropped, so did the value of their homes. Now folks living in one mid-state neighborhood say something new is dragging their values down even more. News Channel 5's Amanda Hara visited the Waterford subdivision in Old Hickory today. Amanda, what's behind this latest drop in values?
Rory, neighbors are actually pointing to an assisted living facility for the mentally ill that popped up at one of those homes next door. Not only does that violate the Homeowners Association covenants, but neighbors say it's simply not a suitable environment to run that sort of facility.
My wife and I actually had looked for over a year for a house, and when she found this house, it was perfect.
Of course, May's flood changed all of that. Property values dropped, homes sat empty, and then neighbors say something unusual started happening at this home.
I know they have mental illness, and they've been scaring some of the children, talking out, cursing.
My daughter was outside playing, and one of the girls that live in that house had come up to her asking for cigarettes or money. And kind of scared her.
Neighbors say that instead of moving back into this home, the owner repaired it and then started using it as an assisted living facility for mentally ill adults.
I understand they have a right to live too, but I thought these were single-family homes. And I was hoping they would stay that way.
Neighbors say all of this violates the Homeowners Association bylaws, which read, no activity, whether for profit or not, shall be carried on any lot which is not related to single-family residential purposes.
I wasn't thinking that people were going to be knocking on doors asking for cigarettes or money or, you know, going around to the kids in the neighborhood asking for that kind of stuff. You know, this is a nice neighborhood, and we want to keep it that way.
But it's not just their property values or children these neighbors are concerned about. There's a genuine fear for the safety of the adults living in this home.
There have been people out here walking around unassisted. We've been concerned about their welfare. A couple times ladies been up here by the sign, out of breath, panting. I don't think the backyard's fenced in for that place. There's a steep drop off to the river up there.
And a spokesperson for Metro's legal department says this is likely a civil matter between the neighborhood and the homeowner. He says the only way that the city would actually get involved, Roy, is if zoning ordinances have been violated. And so far, we've been unable to get in touch with anyone with the city that could tell us whether or not that's the case.
All right, we'll keep an eye on this, though. Thanks, Amanda. And by the way, we also tried getting in touch with the homeowner, but so far we have not had any luck.
Folks in one area of Goodlettsville have serious questions about some new additions to their neighborhood. A group home has moved in, and what the residents don't know about it is making them nervous. Channel 4's Nancy Amons is live tonight with that story. Nancy?
Well, Demetria, this group home is on the other side of this school, the Madison Creek Elementary School. It is licensed by the state, but neighbors say they have a lot of questions that no one seems to want to answer.
We just don't know enough.
Some residents in the Windridge subdivision in Goodlettsville have a lot of questions about the people who live in this house.
Safety is the concern because your worst fear is the unknown.
Around the first of the year, a company called Gabriel Residential Services opened a group home here. Quentin Roberts is one of the owners. And these folks have nothing to be worried about?
Not a thing.
The home is licensed by the State Department of Mental Health and Developmental Disabilities, but there were no public hearings, no zoning changes. And although the neighbors' covenants allow only single-family homes here, the neighbors say they're told there's nothing they can do.
Anytime we ask any questions, we're threatened with a discrimination lawsuit.
According to the Tennessee Fair Housing Council, it's illegal to discriminate on the basis of race, color, sex, or handicap. And under federal law, those handicaps could include mental illness, alcoholism, or drug abuse. Goodlettsville police confirmed they were called to the home twice after a resident went missing for several hours. But the business's owner says residents are not locked down, says they're free to come and go as they wish. Did the police come out here several times?
No, they came out for emergencies only.
What kind of emergencies?
It was just a slight emergency, that was all. I'm not going to get comment on that.
On another occasion, neighbors say a resident was in someone's backyard peering in the windows.
We're really in the dark, and so we've started to get active and vocal about it. We want to know what's going on.
Now, according to the state, the home is a supportive living facility for up to 7 adults with mental illness. They say those clients are supposed to be supervised 24 hours a day. What some residents want to know is by whom and how closely. Nancy Amons, Channel 4 News in Goodlettsville.
Nancy, thank you. And we do want to mention a Channel 4 employee lives in that Goodlettsville neighborhood.
Hello and welcome to Navigating NIMBY, a session about addressing opposition to housing for people with disabilities in residential neighborhoods. These homes are generally otherwise known as group homes for short, but of course they cover a wide range of types of residents and issues that they are seeking to help those residents with. The major topics we're going to cover today are state, local, and federal law, including some case law that's come out in the last few years. Myths about about housing for people with disabilities, because these are the things that you as a city official or planner or decision maker are likely to hear over and over and over again from neighbors who misunderstand the nature of this housing. And then we're going to talk a little bit about city officials' duty to affirmatively further fair housing and how the issue of land use and group homes comes to play in that topic. So, in terms of the law, we're going to talk about a statewide zoning law, local zoning ordinances, and how they affect the ability of people with disabilities to live in the neighborhoods of their choice, the Fair Housing Act, and other fair housing laws that might come into play, or other just general anti-discrimination laws that may come into play when you are faced with these situations. First thing to talk about is what we call the statewide zoning override law. A zoning override law generally is a law that overrides what might be conflicting provisions in local ordinances. And Tennessee's zoning override law with respect to group homes for people with disabilities is found at Tennessee Code 13-24-101 through 104. And what that zoning override law does is basically define a single-family residence to include 8 or fewer people with disabilities plus up to 3 care attendants. So while most local zoning ordinances would say you're not a single family if you have more than 3 unrelated people in the home, you could have perhaps any number of related people, but only up to 3 unrelated people. This zoning override says, for purposes of local zoning, if you have up to 8 people with disabilities living with up to 3 caregivers, that's going to be considered a single family, and that's going to supersede any local zoning ordinance provision to the contrary. Now, the one catch with the statewide zoning ordinance, the statewide zoning override law, is that it only applies to homes that are operated on a non-commercial, i.e. nonprofit basis. The statute uses the phrase non-commercial, but a case that has come along, that came along since in the early 90s, interpreted that to mean nonprofit. So if a group home is being operated by a nonprofit organization, it's going to be covered by this zoning override. If it's operated by a for-profit concern, then that for-profit concern is going to need to look at the local zoning ordinance and perhaps ask for a reasonable accommodation, which we'll talk about a little bit later. So the significance of this is that these homes should be able to just basically open up in any residential single-family neighborhood without having to get anyone's permission. They have the same right to move into the neighborhood that the Smith family would, for example. This statute also overrides private restrictive covenants that might be recorded on the deed, like single-family homes only, because for zoning purposes, this is a single-family zone. Now, besides the state law, several cities have their own definition of family that accomplishes much the same. They've all got their own little nuances about how many people in the home and whether there has to be a nonprofit involved. For example, Nashville has an ordinance that allows up to 8 unrelated people. Now, the language I'm about to use is the language that's from the ordinance. I don't really necessarily approve of this language, but not more than 8 unrelated mentally retarded, mentally handicapped, or physically handicapped persons, including 2 additional staff. So it's a little bit tighter than the statewide zoning ordinance in that it only allows up to 2 additional staff. However, the Nashville ordinance does not make a distinction between for-profit and non-profit. So a for-profit concern seeking to open a group home in Nashville at least doesn't have to worry about that. Murfreesboro, not more than 8 unrelated mentally retarded or physically handicapped people plus 2 additional staff. So very similar to the Nashville ordinance. Memphis, 8 or fewer plus up to 3 staff. Non-commercial only, so it tracks the state law. Unfortunately, goes further and requires state licensing and or city approval. Not all group homes are licensed because not all group homes need to be licensed. Group homes that need to be licensed typically are, for example, group homes for people with mental illness where they're actually providing some services. There maybe have somebody on staff dispensing medication, cooking for them. So it's more of a supportive living sort of situation. Whereas you get unlicensed group homes that really don't provide anything other than a roof over their head, and the residents are expected to operate fairly independently. A good example of this is the Oxford House model, where the residents are there together to recover from addiction, and they choose their own roommates, and they have their own rules, and they basically do their own thing. So you can see there's sort of a spectrum of types that fall under this general category we call group home. And so an Oxford House typically is not going to be licensed because it won't need to be. It's not providing services that require the oversight of the state. Knoxville and some other cities have adopted the state law by reference. So their provisions are going to track exactly what is under the state law that we discussed previously. Let me get back to that issue of unlicensed group home. You will often see that phrase used in bad news reporting, as though unlicensed means bad or seedy or run by criminals or whatever. But unlicensed simply means that they're not licensed. If they're required to have a license and they don't, of course, that's not a good thing. They should, they need to submit to the oversight of the State Department of Mental Health and Substance Abuse Services. But if they're not required by law to be licensed, there's no reason for them to be licensed, and they shouldn't necessarily be considered inferior or Dickensian or something just because they have no need for a license. So just want to make sure that, that terminology, when that comes up, it implies something bad, but it's not necessarily. So moving on from state and local regulation of group homes, we have the Fair Housing Act. The Fair Housing Act was originally passed in 1968 in the immediate aftermath of the assassination of Dr. King. And when it passed, it only covered race, color, national origin, and religion. Sex was added as a protected class in 1974, and then Congress added 2 new protected classes in 1988. One of those was disability, what the Fair Housing Act calls handicap. Again, sometimes there's some not so modern language that's going to be thrown around in this presentation, but it's because that's just sort of what's in the law. So disability and familial status were added in 1988. And if you ever get bored and want to read the preamble to the Fair Housing Act and some of the legislative history, you'll see very clearly that one of the things Congress had in mind when it added disability to the Fair Housing Act was to protect group homes from the kind of discrimination that they had seen for years and years, to remove zoning barriers and other forms of discrimination against group homes. Just before the Fair Housing Act was amended in 1988, well, I take that back. Just after it was amended, the Supreme Court released a decision in a Supreme Court case called the City of Cleburne case, in which it found it was unconstitutional for a city to discriminate against group homes for people with disabilities. It was unconstitutional under the Equal Protection Clause. So by the time the Congress added disability to the Fair Housing Act, the Supreme Court had already sort of taken care of the problem, but the Fair Housing Act provides us with far more tools for enforcement, and enforcement even against non-governmental actors, which the the Supreme Court case did not. It would only have been effective against governmental actors. And sometimes private actors do get involved in these cases, as we'll see, because it's private actors, neighbors, who are generally going to be the loudest opponents to these group homes. And they will sometimes cross the line into violations of the Fair Housing Act. So, something to keep in mind. So, how is disability or handicap defined under the Fair Housing Act? A disability under the Fair Housing Act is a physical or mental impairment that substantially limits one or more major life activities. But it can also be a simple record of having had such an impairment. One doesn't need to have one at the present time to be covered by the Fair Housing Act. If somebody is discriminated against because they have this record, then that's going to be covered. It's also covered if someone is just regarded as having such an impairment. For example, if someone is assumed to have HIV just because they're gay, or if somebody is assumed to have a mental illness just because they may, behave in a strange way. So if someone is discriminated against based on a disability they're simply regarded as having, whether they have that disability or not, that's going to be covered by the Fair Housing Act. So what does this have to do with group homes? Well, many group homes, in addition to being sort of a popular housing solution for people with mental illness who are not quite ready to be on their own, group homes are also a very common setting for people who are in recovery from illegal drugs and alcohol. The Oxford House model I mentioned earlier is very much in that vein. 4 or more, typically men, there to support each other through their sobriety and do the 12 steps or whatever method they use to get and stay clean. And people with addictions to drugs and alcohol are considered people with disabilities under the Fair Housing Act. Now, addiction that's caused by current illegal use of a controlled substance is not covered by the Fair Housing Act. That is not considered a disability. It doesn't have to be accommodated. So, for example, if somebody's saying to a landlord, "You can't kick me out just because you caught me making meth in my apartment. I'm addicted to this stuff." That does not work under the Fair Housing Act. Someone who is in active recovery is covered by the Fair Housing Act, and there's not really any bright line to determine what active recovery is, how long a period we're talking about. It's probably more than a week, but there's just not a bright line in the case law at this point to determine when somebody sort of transitions from an active user to someone who's in recovery and thus would be covered by the Fair Housing Act. Under the Fair Housing Act, there are 3 theories of discrimination that are relevant, that come up fairly frequently in the context of cases involving group homes. Those theories are disparate treatment, disparate impact, and failure to make a reasonable accommodation. These are certainly not the only 3 theories of discrimination under the Fair Housing Act. These are just the three theories that are most applicable to your average group home case. So we're going to talk more about those as we go. So disparate treatment is is really kind of the most straightforward form of housing discrimination we see. It's straightforward differential treatment because of someone's race, color, religion, national origin, sex, disability, or familial status. So it could include, in the case of group homes, different terms and conditions, such as requiring a group home to get additional homeowners insurance for some reason. In the context of, just everyday rental outside the group home context, it could be lying about availability, maybe to an African American who wants to rent an apartment. Intimidation and harassment is covered as a form of disparate treatment. It has its own section of the law, as a matter of fact. And certainly group home residents often suffer harassment and intimidation. Making special rules for group homes just because people with disabilities live there. And those rules are not always for the benefit of the people who live there. It's just sometimes they are a way to act as an obstacle to people with disabilities. So that's straightforward disparate treatment, treating a group differently than another group simply because you don't like their group membership, i.e. people with disabilities, people with addictions, people with mental illness, those kinds of things. Disparate impact, on the other hand, it occurs when an apparently neutral policy results in discrimination based on disability, in this case disability. And it can form the basis of a fair housing claim. So basically what you're looking at is a policy that seems neutral on its face, but when put into practice comes down harder on some groups than others. That's not the end of the inquiry. Just because a policy comes down harder on someone than someone else, that's the person or the body, the entity that made the policy has the opportunity to justify it and say that it's a business necessity and furthers a non-discriminatory, a legitimate non-discriminatory end. The plaintiff, on the other hand, can still come back and say, well, no, there's not a business necessity, or if there were, there was a less discriminatory way for you to carry out that necessity. So that's a really sort of oversimplified way to describe disparate impact, which has been in the news quite a bit lately because it was a theory that had been adopted in all 11 circuits of the federal court system, but made its way to the Supreme Court in a Texas case just recently. And in the middle of June, the Supreme Court affirmed that disparate impact is indeed a viable theory of discrimination under the Fair Housing Act. And in a fairly lengthy opinion by Judge Kennedy, he sort of laid out what it would take to bring a successful disparate impact case. So it's very much a viable theory of discrimination, and there are things that municipalities do that aren't overtly on their face discriminatory, but may have a disparate impact when applied to group homes for people with disabilities. The third theory to talk about is reasonable accommodation. A reasonable modification is simply a modification or a waiver of rules, policies, practices, or procedures if necessary for a person with a disability to have the same use of a dwelling as a non-disabled person. Outside the group home context, some examples might be allowing somebody to have an assistance animal in a no-pets community, reserving parking for somebody with a disability, maybe a mobility impairment, where parking is normally first come, first serve. But in the group home case, it comes up most frequently in requests for zoning relief, such as a variance or special use permit, whatever the local municipality uses as its terminology. So, for example, if you were in one of those municipalities that doesn't have its own local zoning override, and say, maybe a for-profit concern comes in and wants to open a group home in a single-family neighborhood, and they're going to have 6 unrelated people, for example, and maybe 2 staff. They're not going to get any relief from that statewide zoning ordinance we talked about because the override, because it's a for-profit, so they can't use that. And they perhaps don't have an opening under the local zoning ordinance, because the local zoning ordinance says our definition of family is no more than 3 unrelated people, and we've got 6. So in a case like that, the group home operator would approach the zoning board of appeals or the planning commission or whatever appropriate body in a given municipality and ask for what's called a reasonable accommodation, and say, notwithstanding the fact that we don't neatly fit within your zoning ordinances and that we've got more than 3 unrelated people living together, we'd like for you to make an exception and allow us to move into this single-family neighborhood, and here's why it's necessary for us to be in this single-family neighborhood. And the people in the home have disabilities and benefit from this communal living arrangement in this single-family neighborhood, and conducting the household in a way that mimics a family. So cities who get these kinds of requests have to analyze them, the way reasonable accommodation requests are analyzed, and this is where a lot of municipalities trip up by failing to do the right analysis and denying this reasonable accommodation, because that's basically going to form the basis of a fair housing complaint all by itself. Some commonly litigated issues when it comes to group homes include zoning, obviously, zoning that might be illegal on its face, dispersion requirements. We'll talk about that more a little bit later. Special safety and procedural rules, restrictive covenants that are enforced by private persons instead of the city, and free speech issues. So as we talked about earlier, we mentioned single-family zoning is an issue in a lot of cases. In a typical municipality, single-family zoning often is going to prohibit more than 3 unrelated people from living together. Generally will allow practically any number of related people to live together as long as they don't violate whatever occupancy code might be in place to prevent overcrowding. A failure to issue a variance for a group home, as I mentioned in the previous slide, can be illegal if they ask for a reasonable accommodation and say, hey, we behave just like a family, we need to be together in this family-like model in this setting. So that can often be illegal on the city's part unless they can show that allowing this group home in this single-family neighborhood would somehow be an undue financial and administrative burden on the neighborhood or on the city or whatever, maybe with traffic and whatnot. In most cases, the housing provider, whoever is operating the group home, must ask for a variance if they need one to open. They can't necessarily just say, well, I think ultimately the Fair Housing Act provides us with a right to be here. If you are in violation of the local zoning ordinance, or if a provider is in violation of the local zoning ordinance, they need to request relief from that zoning ordinance in the form of a variance or special use permit, unless they've already know that it's going to be a futile gesture. If somebody at the city has already told them, or better yet, put it in writing, don't bother, the neighbors don't want you there and we're not going to let you be there either, then that might be a signal that someone's application for zoning relief is not going to be successful, is going to be futile. So in that case, they're not required to sort of exhaust that administrative process of going through the variance procedure. And, as we mentioned, the state zoning override or local definition of family may make that unnecessary. There's restrictive zoning that goes beyond just sort of not providing for group homes, but actually relegates them to pretty unattractive surroundings. For example, there was a town near Nashville that did not allow, quote, personal and group care facilities, which is what we're talking about here, in any residential zone without special permission, unless the home has 8 or fewer people, is licensed and operates as a nonprofit. And so the city took to telling group homes that they were going to have to be rezoned or just move. There was another city not far from Nashville that basically relegated group homes to the parts of town where they also, smash junk cars and dispose of dangerous chemicals and whatnot. So basically sort of shuffling group homes off with the other noxious uses, which I think is pretty good evidence of discriminatory intent in that case. Spacing requirements pop up from time to time in zoning ordinances. I haven't seen a lot in Tennessee that do this, but a spacing requirement basically involves prohibiting more than one group home from existing within a certain number of feet of an existing one. In most cases, those spacing requirements are going to be illegal or at least very, very suspect. Because it denies housing choice. It's hard to imagine a case where it would be okay for a city to say, okay, we're going to set this spacing requirement where we don't want one African American family to live within 500 feet of another African American family. I mean, we know just hearing that that's appalling and would be illegal. Yet we often accept that cities do this with group homes, and there's not really any logical reason that there should be a distinction. But dispersion requirements were found legal in one case out of Minnesota several years ago, where there was excessive clustering of group homes on a single block, which created a mini institution. So the judge in that case said, that the company that bought up all these group homes and put them in there in the one just square block had created sort of a mini social services district, which really basically defeated the purpose of having people in the community anyway. The ideal thing is to have some community integration. But if you just add group home to group home to group home, and then maybe have a treatment facility right there too, you've just created another institutional setting for those same folks that deprives them of the integration that they moved there for in the first place. And operators, will do this for a number of reasons, mostly economic. Sometimes they'll find a neighborhood with a lot of foreclosed houses for sale that they can buy up pretty cheaply, but I always recommend that they avoid that kind of clustering. And as a matter of fact, in a recent case, the Department of Justice agreed to a settlement that did have a spacing requirement. It was lowered from 2,500 feet to 500. So it allows more density of group homes than the original one did. But still, the Department of Justice didn't disallow the spacing requirements, out of hand. So let's talk about some cases where cities have imposed special rules for housing for people with disabilities. And these are generally going to fall into two categories in the case law that we've seen over the years. One of those categories is measures for the safety of the community, and the second is measures for the safety of residents. And we often find in the latter cases that some of the reasoning behind those rules is a little disingenuous and mostly meant to provide an obstacle to group homes opening. So we'll talk about those in a little bit more detail. Cases dealing with community safety measures, in other words, measures that protect us from that scary group home, have included things like a requirement of 24-hour supervision, even if the population at hand doesn't need 24-hour supervision, they're able to live independently. Community advisory panel that sort of gets to know who's moving in there and decide who gets to move in and who doesn't. Tall privacy fences so people don't have to see the house or its residents. Armed guards, again, where it's not necessary that there be that level of security. And disclosure of names and medical histories of residents. There have been cases where cities have tried to require that. And those are usually going to be illegal because they're based on stereotypes. Not all people with mental illness are alike. Not all people with substance abuse issues are alike. And so to have these blanket requirements, not only do those act as barriers to group homes, but they also just really kind of betray a very discriminatory attitude. cases involving measures that were put in place for the protection of the residents also involve some fairly interesting facts. Expensive life safety equipment sometimes is required. 24-hour care when it's not really required. Yeah, you can have that group home there, but we want to make sure that you've got somebody on staff, 24/7, keeping an eye on them. Well, as I mentioned in the Oxford House model, generally they don't have on-site staff. They take care of everything themselves and live pretty much completely independently. These kind of measures are going to be illegal unless they're specifically tailored to the disabilities of the individuals in the home and truly for their benefit, and not just as a way to make it too expensive to open a group home. Tennessee cities, unfortunately, are bound to follow the state's fire code, which doesn't really have any flexibility built in. But, and fire codes are a really good example of ways that group homes often, run into problems. The National Fire Protection Association has a code called the Life Safety Code 101. And in there, for example, it requires that small group homes of, I think, up to 8 people must get sprinklers unless the residents can be shown that the residents can get out of the house in a reasonable amount of time in case of a fire. So you can imagine a situation in which 2 different group homes might have a different situation with respect to sprinklers. Say an Oxford house, for example, where everyone is, generally, they know how to react appropriately in an emergency, that are physically able to get out of the unit if there's a fire and they can call somebody. That sort of home is quite different than a group home that might have a group of non-ambulatory people with developmental disabilities who need help, getting out of bed, getting into wheelchairs, that sort of thing. That group is going to have a little tougher time getting to a point of safety within just a couple of minutes. So that home, in a home like that, it might be more reasonable to require sprinklers to help mitigate the danger while they get out. But to require a home with individuals that don't have any of those physical impairments and don't have any mental impairments that keep them from reacting appropriately to an emergency like that, there's no reason to require them to have sprinklers. A few years ago in Nashville, the city adopted that the life safety code and took out the language that made an exception for group homes where people could evacuate quickly. And fortunately, we communicated with them and they changed it back and adopted the language, the original language of the life safety code, and so restored some balance to it. So it's all about tailoring those requirements to the needs and abilities of the people in the group home, and it requires making an individualized assessment of each group home to determine whether they need that safety equipment, and that might mean running a fire drill. It's very common for the fire marshal to come and run a fire drill and see how quickly this particular group of people can evacuate to a point of safety, and then make the decision whether to require them to have the sprinkler systems. Sprinkler systems are prohibitively expensive in a lot of cases in existing structures, especially older homes where the water pressure may not be so great. Let's talk about private restrictive covenants. We've talked a lot about what governments do to sometimes hinder the ability of people with disabilities to live in group home settings and single-family neighborhoods. Private actors also get in on the act from time to time through a use of something called private restrictive covenants. You're probably familiar with covenants, maybe more so in the racial context. For a long time, neighborhoods routinely had language in their covenants that required, for example, that this home not be sold to anybody who is not of the white race. In fact, the federal government was actually requiring group homes, requiring single-family homes built in the 30s and 40s with FHA loans to have these kind of restrictive covenants, and their enforcement was struck down in the 60s. But they also pop up sometimes in the context of group homes, where neighborhoods will have a restriction that says families only, or they'll have some sort of restriction that says residential use only, and they'll try to claim that the group home is a commercial use simply because there are people living there who don't own it and who may pay rent to some outside party. But generally, those restrictive covenants have been found to be inapplicable to group homes because of the Fair Housing Act. They could be asked to waive the application of those covenants as a reasonable accommodation, the same as somebody could come to the city and ask for a zoning restriction to be waived. Suing to enforce a discriminatory covenant can be grounds by itself for a Fair Housing Act suit or countersuit. And they're also superseded by that statewide zoning override that we discussed earlier. So they're treated just like a zoning ordinance for purposes of that statewide zoning ordinance. If you work for a municipality, a planning commission, if you're on a city council, any kind of elected official, you are often going to hear from neighbors who are not happy about this group home going in next door. And that's okay. They are complaining to you, and that's a protected activity under the First Amendment. And they can't be sued just for expressing an opinion, no matter how ill-informed that opinion might be. And they also have a right to access the courts, to file suits that aren't frivolous and motivated by an illegal purpose. They don't have a right to harass, vandalize, or trespass. And we have seen a lot of cases where neighbors who are unhappy about a group home, videotape the home 24/7 in a way that's very intimidating. I had a case several years ago where a couple of neighbors who didn't like a group home actually came into the yard and interrupted a birthday party by taking pictures of the people who were there. So that kind of activity falls outside the protection of the First Amendment and can form the basis for a Fair Housing Act claim. I want to talk a little bit about other federal laws that may come into play. The Americans with Disabilities Act covers municipalities and requires that they provide governmental services in an equal-handed manner, regardless of disability. So this is going to cover how you may apply your zoning ordinance to a group home, how you may treat reasonable accommodation requests. The ADA is going to come into play there in addition to the Fair Housing Act. Section 504 of the Rehabilitation Act of 1973 is going to apply to cities that receive federal funds for their operations. Not all cities receive federal money, but the ones that do are required to operate on a non-discriminatory basis with respect to people with disabilities. So again, a failure to reasonably accommodate or intentional erection of zoning barriers to a group home opening up would violate Section 504 if there's federal money involved. These laws also cover other kinds of facilities, not just dwellings. So while it's outside the scope of this presentation, if somebody just wanted to open a non-residential, say, drug treatment facility somewhere, and we got all sorts of not-in-my-backyard kind of objections, one of these statutes, the ADA or Section 504, might come into play even if the Fair Housing Act doesn't apply, because as we mentioned, the Fair Housing Act only covers dwellings. So this, ADA and 504 might cover something like a methadone clinic or something like that. Let's talk about just a couple of cases. I'm not going to go through all the cases I have in my notes, but I will make this full PowerPoint available for download if you want to see some of the cases that I don't get to during this presentation. But there's been some pretty fascinating stuff that's gone on over the years. Case from 2013 called Candle House Incorporated versus the town of Vestal. Candle House was a company or an organization that wanted to open a 12-bed residential faith-based treatment family for young women with substance abuse, emotional disorders. They purchased 2 properties together that had been used as a church and a church campus. And they wanted to use it as residential with a worship center and a campus for work training. The property was zoned residential, and they asked the city whether they could use the property for a church and a residence for its clients. And there was, of course, community opposition, and the town determined that the proposed use of the property was not allowable in an R1A zone. Candle House took the next step and asked for that reasonable accommodation. Asked the city, would you make an exception in this case, because these 12 women need to live in a communal environment to receive the assistance they need. And they alleged that the city denied the request. I'm not sure what actually happened. The city probably just ignored the request, which can be the same as a denial after a period of time. So Candle House started using the property for its religious purpose, because it had previously been in use as a church, so they didn't really have any problem there. But the residential activities had to be done off-site at great cost to Candle House. So they sued and alleged disability discrimination under the ADA and the Fair Housing Act, and a substantial burden on religious exercise under the Religious Land Use and Institutionalized Persons Act, which is another federal law that applies sometimes but is really outside the scope of this presentation. The court dismissed the religion claim, said their religious practice was not being burdened, but asked the court to find in their favor on the intentional discrimination and reasonable accommodation claims. And the court allowed those claims to proceed to trial and said, the jury should get to decide whether the city was motivated by discriminatory intent. It did go to trial, and the jury found that there was intentional discrimination, but awarded only $4,700 in damages. The parties reached a settlement of more than $250,000 in costs and attorney fees, which under the Fair Housing Act, it's called a fee-shifting provision in the Fair Housing Act that allows the successful plaintiff's attorney to recover fees and costs. This Pacific Shores case has been in the news very, very recently, just in the last few weeks. And the case started, back in 2007, 2008, so you see how long these things can go on and tie up city resources and so forth. A wealthy city in California, Newport Beach, passed a moratorium on new group homes and then passed another ordinance making it harder for group homes that were already open to remain that way by submitting them to a new and burdensome permit process. The city changed the definition of single housekeeping unit so that most would not qualify, and group homes would now be residential care facilities. It's amazing what you can accomplish just by changing a definition here and there. The city also went after some temporary housing for non-disabled persons, for example, just plain old boarding homes, to give the restrictions what the court called a veneer of neutrality. The city thought, well, we'll make this look non-discriminatory by coming down on boarding homes too. But it was clear that there was discriminatory intent just based on what local officials had said and what the neighbors had been saying. So there was a burdensome permitting process that required, staff time, legal fees that the group homes couldn't necessarily afford. And the number of group homes in Newport Beach was sharply reduced by this new policy on the part of the city. So 3 of the group home operators sued the city, and the trial court found that they failed to prove discrimination because they did not show that they were treated worse than other similarly situated parties, like the temporary lodgings, even though there was ample evidence of discriminatory intent. That's exactly what the city was hoping would happen when they broadened their ordinance to cover non-protected temporary uses like boarding homes and so forth, temporary lodgings. The trial court also said that the homes were not single housekeeping units. The court ruled that the processes for special use permits and reasonable accommodations were not discriminatory, and the plaintiffs did not produce adequate evidence that the city's new regulations harmed their businesses. So, of course, they appealed, and the appeals court, the Ninth Circuit Court of Appeals, reversed most of the holdings that the trial court had made and said where there is evidence that the defendant has acted with a discriminatory purpose and has caused harm to members of a protected class, there's enough to go to trial. It doesn't matter if others were also treated very badly. It was clear in this case that one of the reasons for this broad restriction was animus against housing for people with disabilities. The city then tried to appeal to the Supreme Court. Supreme Court said no thanks, and so the city and the parties in this case came to agreed to a settlement of $4.15 million, which I don't know how much of a chunk that is out of the city of Newport Beach's budget, or if insurance covered it or whatever, but I think that some people would probably say at this point that, you know, that's maybe was not the highest and best use of the city's money to pay a settlement to, you know, as a result of carrying out a discriminatory policy. HUD versus Miller is a case from just a couple of years ago. This is a case that was filed as an administrative complaint with HUD, Department of Housing and Urban Development. In Worcester, Mass., the complainants, the operators of this group home, they wanted to buy a home and rent it to a nonprofit who would use the home as a group home. This is actually a pretty common arrangement. The people who operate the group home don't always own the home. They sometimes will rent the home from someone else and then use it as a group home, and there's nothing wrong with an arrangement like that. It's just a plain old landlord-tenant arrangement. So the complainants allege that the seller and his agents, once they learned what the house would be used for, basically had a restrictive covenant added to the deed that would prohibit future owners of the property from using it as a group home for people with disabilities. The case settled. The defendants in this case will pay a total of $90,000. And I really like this part. The law firm that recorded the covenant that they knew was, or probably should have known, was discriminatory, will donate 200 hours of legal services directly related to fair housing and the promotion of disability rights. So 200 hours at your typical private firm rate, that's $4.5 billion. Well, probably not that high, but still, that probably hurt. Let's talk about one more case, this one involving Oxford House versus City of Baton Rouge. Oxford House, just to give you a little bit of background, has really been on the cutting edge of group home litigation because they've been around so long. It seems like they have to litigate almost everywhere they go. So they've been around the block a time or two with respect to these kinds of disputes. So Oxford House sued the City of Baton Rouge, alleging that its zoning ordinance violated the Fair Housing Act by preventing them from operating two homes for persons recovering from alcohol and drug use. The homes were going to be located in areas that were zoned single family. The Oxford House asked for reasonable accommodations from the city, and the city refused. The court found that not only was the zoning ordinance facially discriminatory, but that the reasonable accommodation that Oxford House had asked for was necessary and did not impose an undue financial or administrative burden and would not fundamentally alter the city's zoning scheme, which is, those are potential defenses to a reasonable accommodation claim, and the judge found that those defenses were just not available in this case. So that's all the discussion of cases right now. Again, this presentation will be available for download if you want to get the names of all those cases and summaries of them. I probably went through half of the ones I had in the presentation. Now I'd like to talk a little bit about the myths and truths around group homes, because you hear all kinds of things about group homes, most of them not very complimentary, and generally from people who don't want the group home there. And so I think it's useful for people who make these kinds of decisions to be aware of what the real facts are, and so you can separate fact from fiction when people who don't want these uses in their, in their neighborhood come to city officials and ask that it, be stopped somehow. The main categories that these sorts of arguments, these myths tend to fall into are that a group home is going to lower our property values, that a group home is going to result in an increase of crime in our neighborhood, and that we already have our fair share of group homes in this neighborhood. So let's talk about property values first. Property values falling as a result of group home, the presence of group homes, is right up there with Bigfoot and the guy who left his hook arm on the handle of somebody's car, or the Loch Ness Monster. Study after study just doesn't demonstrate that this is the case. Property values generally don't decline in the presence of housing for people with disabilities. It just doesn't happen generally. And in fact, in some cases where the neighborhood is somewhat distressed already, the rehabilitation of a vacant home into a group home can actually improve property values in the home. Sometimes the group home is going to be the nicest house on the street. Now, you do sometimes see temporary downticks in property values where there's been panic selling or blockbusting because of prejudice. I consider that very much a self-imposed, self-inflicted wound, and don't really feel very sorry for people who lose value on their property simply because they were afraid to live next to some people who are recovering from drug addiction. The more reliable predictors of property values are things like schools and jobs and neighborhood conditions and neighborhood amenities. Those are the things that affect property values, not the mere fact that there is a group of people with disabilities living nearby. So when you're confronted with those arguments, know the facts. It's not hard to find studies online, reputable studies by industry groups such as the National Association of Realtors. They are all pretty well in line with each other about the lack of impact on property values. So it's a good thing to be armed with that knowledge when, if you're hearing from neighbors that property values are going to go down. There's always also a concern about crime. Studies show that the public grossly overestimates the dangerousness of people with disabilities. In fact, people with disabilities, especially people with mental disabilities, are far more likely to be the victims of crime, not the perpetrators. So, to the extent there is a risk at all, it can be fairly effectively mitigated by careful screening and appropriate placement to keep risks to a minimum. But the idea that the presence of a group home is going to cause crime to go up in a neighborhood is, it's like the property value argument, largely unfounded. So let's talk about a municipality's duty to affirmatively further fair housing and how that fits into this whole matter with group homes. Since the passing of the Fair Housing Act in 1968, municipalities, towns, states, any governmental entity that receives certain kinds of federal funds from HUD is required to use those funds to affirmatively further fair housing. That requirement extends to municipalities that receive community development block grant funds, either directly from HUD or as a pass-through as a small city from the state, which also receives CDBG funds. The affirmatively furthering fair housing, I'm gonna call it AFFH, requirement also extends to public housing authorities and cities that have public housing authorities. So what does it mean to affirmatively further fair housing? Well, HUD recently passed a new rule. It's not completely finished, but they passed a new rule that is supposed to equip communities that receive HUD funding with data and tools and things that they need to meet their fair housing obligations and their use of HUD funds. And the goal of this rule, this new rule, is to provide HUD grantees with clear guidelines and the data that will help them achieve these goals because, quote, no child's zip code should determine her opportunity to achieve. In its new rule, HUD spends a lot of time really emphasizing racial segregation and its causes, and that it really is the brunt of the rule to sort of mitigate and counteract the historic racial discrimination in this country that was partially caused by the federal government's own policies for a long time. But beyond race, it also requires covered entities, the governments that receive federal money, to analyze how their local land use roles might affect the ability of people with disabilities to live in the communities of their choice. So it's incumbent upon jurisdictions to take a long look at their zoning ordinance to see what provisions in there might act as impediments for group homes to operate. Might either be outright prohibitions, or you can have a group home here, but it's got to be out near where they dispose of the paint thinner, or just ordinances that have some sort of disparate impact. So that's going to be part of every HUD recipient's obligation to affirmatively further fair housing. So some examples of potentially problematic zoning: overly strict definitions of family and not allowing reasonable accommodations for groups that are larger than that. Restrictions on rentals in single-family neighborhoods. There's generally going to be some sort of landlord-tenant relationship whenever there's a group home. Either the group home operator is renting from an owner and the residents in turn are renting from the group home operator, or maybe the group home operator owns the home, but the residents are still renting from him or her. So disallowing rentals in all single-family neighborhoods would certainly have a disparate impact on group homes. Restrictions on lot size that would prevent construction of new single-family homes for people with disabilities. Sometimes group homes are built from scratch, and then in some cities it's prohibitively expensive because they might have the city might have a minimum square footage requirement for the house, or not allow a house to be sold for less than some ungodly amount that most people can't afford. So those are things to be sort of on the lookout. And just any other obstacles to affordable housing in general. A hostile populace, a hostile planning commission, a hostile zoning appeals board. Those are conditions to be aware of, so that not only do you avoid getting sued, but you also avoid losing federal funds that your community might need very badly, because that's HUD's way of enforcing its AFFH requirements. So as I mentioned, even if you don't get any federal funds, municipalities are still required to follow the Fair Housing Act, and as such should go through and analyze their zoning ordinances very carefully to make sure that they don't act as a discriminatory hindrance to group homes locating in a neighborhood. We're providing our contact information for myself at the Fair Housing Council. My colleague Carol Gish at West Tennessee Legal Services, her agency covers most of the state that we don't cover. I've put some legal aid, I'll make some legal aid phone numbers available to you on this video. And we look forward to working with anyone who needs any sort of assistance or guidance on these issues. Thank you very much.